Good afternoon, everyone, and welcome to Anti-Slavery Australia and My Blue Skies webinar on forced marriage protection orders. My name is Grace Thangasamy, and I work as the project manager and the lawyer specifically for forced marriage matters here at Anti-Slavery Australia. I'm going to take you through some of the slides on basically the scheme of forced marriage in Australia, the criminal offence provisions, and an introduction at a very high level to the UK forced marriage protection orders. As you'll see, we've got some experts who are going to assist the discussion today, looking at existing protections under Australian law for those affected by forced marriage, and that is primarily remedies under the Family Law Act, and then case studies of those. And further on, I will go on to speak about protections under the Australian law for those affected by forced marriage under state and territory domestic and family violence protection orders. Under Agenda Point 6, you'll see that we will have an open discussion with representatives from Legal Aid New South Wales and Lander & Rogers about what features an Australian forced marriage protection order should have, drawing on the case experience of practitioners who work under domestic and family violence legislation and the Family Law Act currently. And also give an opportunity for representatives from Home Affairs to speak about the Australian developments, timelines and opportunities for consultation for a forced marriage protection order scheme here. We'll then conclude with reflections or remarks from our main presenters and questions from the audience. As you can see, you can ask questions via the chat option on Zoom. And also, it would be helpful if you put yourself on mute with no video as we proceed through the webinar. Really what we want to do today is to give you an introduction to what scheme exists in the UK, look at the remedies that are currently available and are being used by people at risk of forced marriages or who have been forced into a marriage here in Australia, and draw out some of the features that we think are working well within the current system and some of the features that need to be improved and could be improved by the introduction of a forced marriage protection order scheme. We want you to be able to walk away with a better understanding of the current frameworks and the current protections, specifically in the family law space and the domestic and family violence space, while acknowledging that there are obviously a lot of remedies and great initiatives that are being undertaken by child protection under their own legislation in each state and territory around Australia. Above all, we want you to be able to come out with a really practical understanding of how forced marriage protection orders, if implemented in Australia, could provide a preventative space for people affected by it, and how that might sit within the current schemes that we have, which we assume will continue to exist even after the potential introduction of these forced marriage protection orders. So just to give you a very short overview of forced marriage in Australia up to this point, many of you would have read Jennifer Byrne and Francis Simmons' article Without Consent in the Melbourne Law Review in 2013, which included a recommendation for Australia to introduce or consider introducing a forced marriage protection order scheme that is similar to the one in the UK. In August 2018, this year, the Australian government announced its intention to develop a forced marriage protection order model by the conclusion of the year. From 2013 to June 2018, the update that we received from the Australian Federal Police at Anti-Slavery Australia's Forced Marriage Conference was that there have been a total of 232 cases of forced marriage that have been referred to the AFP nationally. But all practitioners in the space commonly recognise that we believe this report rate is under the estimates of the people that the number of people that we work with who are affected by forced marriage generally. As we know, there are no convictions yet under the criminal forced marriage offence in the Criminal Code Act of the Commonwealth under 270.7 be, although there are a number of convictions that have happened under different state and territory legislation or under the Marriage Act for cases or scenarios that had forced marriage elements, like the one in Noble Park in Victoria, for example. We do know that there are a number of cases that are trying to be tested under the forced marriage criminal provisions, but we have yet to hear about any results under that, and that they are currently before the courts. In terms of preventative legal action that forced marriage, I guess, victims or those affected by it might have under the Family Law Act and under state and territory family violence legislation, there are a variety of remedies, from personal protection orders to property recovery orders to injunctions. And I've just listed a few examples of legislation that might be relevant in the area, and I will go into that in more detail later. But these types of legislation generally prevent travel, can prevent further stalking or harassment or intimidation, and also allow for a limited opportunity to recover property such as passports or personal belongings that someone who has been at risk of forced marriage might want to lay claim to from their parents' or relatives' houses or possession. In terms of the UK Forced Marriage Protection Order Scheme, the relevant legislation I've listed there in the red box on the left, one act for England and Wales and then one for Scotland. I've listed the courts that these orders can be sought in, to the High Court or the Family Court, and I think the last time I checked in England and Wales, for example, there are about 33 different High Courts or registries from which forced marriage protection orders could be specifically sought across that area. Who can an order be made against? So generally the categories are very broad. So whoever might be forcing or attempting to force a marriage, or may force or attempt to force a marriage, could have an order made against them. And also people who are kind of on the periphery, so persons who are or may become involved in other respects. And this phrase, other respects, is defined specifically in the legislation and has a very broad definition, including anyone who aids or abets or conspires to or procures and helps basically someone who is forcing or attempting to force a marriage. I'll just note that this is in contrast to many of the, for example, the actions that are currently available under the Family Law Act or under the domestic and family violence legislation, which requires specific defendants to be listed, generally the person who is primarily the person that someone is seeking protection from, and the ability to cover third parties is a little bit more awkward. So people that have some sort of connection or the defendant may have some sort of control over these kind of, parties might have to be formally joined to proceedings in order for the order to cover them. Who can make an application for a forced marriage protection order in the UK? Applications for a forced marriage protection order may be made by a protected person, so a person who's seeking protection who's at risk of the forced marriage in the first place. They call relevant third party, including someone like a local authority, for example, a child protection agency or a local council, or any other person with the special leave of the court. And there's 2 points to really note about this idea of standing or who can make an application in the first place. Firstly, relevant third parties, such as a local authority, can actually make an application without the knowledge or even the consent of a victim. And that courts can initiate the making of a forced marriage protection order within other proceedings, for example, a family court proceeding being commenced. It doesn't require its own specific commencement. Courts can actually look at a situation in certain other proceedings, for example, criminal or family law proceeding, and say, I think a forced marriage protection order might be appropriate in this case, and make that order within that set of proceedings. What can a forced marriage protection order do? Under the English and Scottish Acts, they can include generally prohibitions, restrictions, or even a positive requirement, such other terms as the court considers appropriate for the purpose. And the main purpose of a forced marriage protection order is basically to prevent someone from continuing to be harmed, either by placing them at risk of a forced marriage or allowing for protection of someone who has already been forced into a marriage. It's really important here to note the differences between a prohibition, a restriction, or a requirement. Prohibitions and restrictions are generally something that is covered in the domestic and family violence legislation that we already have. So prohibiting someone from approaching someone else or from visiting their place of work or their place of schooling, restricting them from harassing or intimidating, but very rarely, and this differs across schemes in states and territories, do they require a person covered by the order to do something positive. Generally, a positive requirement, and the only positive requirement that these types of orders can ask someone to do is to provide a property back, a return property back to the person in need of protection. Under the Forced Marriage Protection Order scheme in the UK, it's possible for an order to provide for a seizing of a respondent's passport, requiring the respondent to reveal the whereabouts of a protected person or a victim, preventing them from having contact with the victim, allowing the victim to assume a new identity, even ordering that a marriage or a marriage-like form may not take place between certain parties, ordering that the victim can't be taken out of the country, which is a very similar order which can be made under the Family Law Act. And specifically down the bottom here, which I think is most useful in a preventative capacity, is to disclose, if known, the whereabouts of a person and to refrain from taking the protected person from or to such a place as the court may specify. This may be out of the country or to another part of that same country, and to submit to the court documents including birth certificates, passports, and other identifying documents and travel documents. So it is broad-ranging and encompasses a lot of the situations that we see in our casework to do with travelling overseas, return of personal documents, when people affected have left the home and are unable to gain access to all the key documents that they need to set up a life independently of their parents or their relatives. And importantly enough, refraining from taking a person, whether or not they're under 18 or over 18, to such a place as to, for example, overseas to get married, is a really important feature which is not currently available under our remedies, our legal remedies. So the basis for granting a forced marriage protection order is that the court must have regard to all the circumstances, including the need to secure the health, safety, and well-being of the protected person. In ascertaining what that well-being might look like, a court must have particular regard to the protected person's wishes and feelings, as long as they are reasonably ascertainable, and to the extent that the court considers appropriate on the basis of the person's age and understanding. And this is a particularly relevant paragraph to children and trying to assess their understanding and their wishes in a particular situation, or someone who perhaps might lack capacity because of a disability. So how has the legislation been applied so far? So since 2008 up to end of 2017, there have been approximately 335 applications for forced marriage protection orders in England and Wales. Approximately 149 of those applications have been made by third parties and not the protected person themselves, noting that exception there where there was missing data from 91 of the 335 applications for forced marriage protection orders. And I thought it might be helpful to talk through some case examples of when forced marriage protection orders have been granted, just so people get an understanding of how that would look like, how that has looked like and played out in common scenarios where we've seen people at risk of forced marriage. So the first one, A and SM and another in 2012, is quite an interesting case. In that particular case, there was a number of parties who were joined to the proceedings, and it was quite a difficult one in many ways because there was so many parties involved in it. So in this particular case, it involved conduct overseas. So the applicant A, who's aged 20, she sought a forced marriage protection order on behalf of herself and her 6 younger siblings. She asserted that on a family trip to Bangladesh, she had reason to believe that her mother and her father were imminently planning to force her into a marriage. And while A, the 20-year-old, was able to escape that particular situation with the assistance of the Forced Marriage Unit at the Bangladesh High Commission, so she was actually in Bangladesh at the time, following her escape, her parents forced her younger sister into marriage against her will. So then when A made this ex parte, so in the absence of her parents, the other party, application to the High Court for a forced marriage protection order at the emergency hearing, the judge there granted a forced marriage protection not only in respect of A, but in respect of her 6 siblings, and made a non-molestation order preventing the parents from molesting or threatening violence towards her or the other 6 children, and directed the parents to produce the 6 children to the British High Commission in Bangladesh and disclose their whereabouts. And not only that, but the parents had to facilitate the return of the children to the British jurisdiction within 7 days of service of the order. And all 6 children were also made wards of the court so that child protection agencies could act and care for them appropriately upon their return. There was also orders for passports of adults and children to be returned. And I think this is a really interesting example, which we'll hopefully cover a little bit later on, of where the extraterritorial application of such an order when parties are overseas would really assist in many of the cases that we see specifically at Anti-Slavery or My Blue Sky, where we have vulnerable girls or boys, men and women who reach out to us while they're in another jurisdiction, who need help returning or need help annulling a marriage or getting some sort of relief, and depending on the country they're in, can have very limited access to not only to our legal system but the ability to return home without their parents or their relatives being able to facilitate that. And so having orders that could apply in such a context is kind of a remedy that we haven't explored and haven't been able to really enforce at all in any shape or form, unless it borders into child abduction type avenues under the Family Law Act, but again doesn't cover over 18s as many of our clients are. So, and also the applicability of those types of orders currently under the Family Law Act depend very much on whether or not another country in which a client is a party to the Hague Conventions that are relevant, and that is a whole different ball game altogether in terms of enforcement if they're not. The second case is the A Chief Constable and another and YK and others from 2010. And this particular case was interesting, again, because there were so many parties, but involved a 19-year-old British national of Pakistani descent who was born and brought up in the UK. And in this particular case, the police made the application in the county court, asking for orders to be made against her parents, so A's parents and cousin, and the orders made were to forbid them from causing or permitting, encouraging, suggesting, instructing, or suggesting to another person that A undergo a marriage ceremony in the UK. Unfortunately, shortly after that application was made, A was actually subject to a forced marriage, and this particular marriage wasn't able to be registered because of the orders that had been put in place by the court before then as well, which was to stop registration of any ceremony that took place between A and this other proposed groom in the UK. I guess what's interesting about this is that in this particular case, there was a marriage-like ceremony occurred, so it covered that conduct and not just a marriage, so a cultural ceremony. It also involved a number of orders that I think show the breadth of what can be covered, apart from just, generally that a marriage should not take place. The parents and cousin were forbidden from aiding, abetting, counselling, encouraging, assisting, taking any steps basically to force or attempt to force a marriage, and allowed actually access for authorities to speak to A alone without the presence of any other persons outside the family home at a venue to be arranged by the police. So that was A's parents were subject to that particular order to facilitate that contact. And they were also ordered to hand over to the police any UK passport belonging to A or her sisters, any other Pakistani passports, travel documents, ID cards, and they were further forbidden from removing A from England and Wales and taking any steps to obtain further travel documents that would enable A to leave England and Wales. I do believe there was also the addition of her groom or the proposed groom's parents, or father in particular, who was also subject to orders, and that was really interesting to see, because often it's not just the immediate family of the person at risk, but also the groom's family, which they can be putting pressure, in that situation. And I guess there's a one point that we can go over in more detail, but we don't have time to now. So I suggest you have a look at the case yourself. But there was quite an interesting discussion here in the case about what evidence should be kept secret, and from the party who's responding to the application for a forced marriage protection order, in order to protect the informant who is giving that information either to the police or maybe to protect evidence that's given by someone who's in need of protection, to provide the grounds for such a forced marriage protection order. And so I think there's some larger questions about due process there, but we don't really have time to kind of explore that in this particular case. So what I'm going to do now is I'm going to hand it over to our two experts in the Family Law Act, firstly Byron Leung and then Anna Boltons, and they're going to talk about parenting orders, the airport watch list and injunctions under the Family Law Act. Let me just introduce you to them and provide a bit of context to their expertise. Byron Leung is a special counsel at Lander and Rogers, and he's been an accredited family specialist who has practiced exclusively as a family lawyer for over 17 years. His practice extends across jurisdictional matters involving countries such as China, Hong Kong, Malaysia, and Laos. This expertise enables him to navigate the complex issues that often arise from international family law matters, and he is currently a committee member of the Court Practice Committee and a former committee member of the Children and Youth Issues Committee of the Law Institute of Victoria. I'd also like to introduce Anna Bolton, who's the Acting Solicitor in charge of the Legal Aid New South Wales Domestic Violence Unit, which is an accredited specialist in family law and an independent children's lawyer. Prior to joining Legal Aid New South Wales in 2013, she worked in private practice in Sydney and in Dubbo, and she's had extensive experience in complex legal matters involving domestic and family violence, including forced marriage matters. And so I will just let Byron start the day with a bit of an overview on the Family Law Act.